You've done the preparation. You've negotiated the LOI. You've survived due diligence. The buyer is still at the table. There's one document left now between today and closing day, and it's the longest, most heavily negotiated document in the entire transaction. The purchase agreement itself. This contract is the one that actually transfers your business. Everything that came before, the LOI, due diligence, the disclosure schedules, all existed to inform this document. And everything that happens now, after closing, the indemnification claims, the non-compete enforcements, and any earnout disputes, will be governed by what is written here. This episode then will walk you through the anatomy of the purchase agreement, on the provisions you need to negotiate the hardest, and what actually happens on closing day. I'm Chad Graham, Alberta corporate lawyer and host of From Build to Sold. This is episode 9. If you've followed the series so far, you're close to the finish line, and this episode is about finishing well. Now, whether your deal is structured as a share purchase agreement or an asset purchase agreement, the core architecture is very similar. Let me walk you through it section by section. You have the parties and the recitals up at the top. This is sort of the opening, where it identifies the buyer, the seller, and, where relevant, the corporation. The recitals state the background intention of the parties. It's largely administrative, but it should be checked carefully for accuracy. The correct legal names of every party, properly identified, matter enormously when it comes time to register a share transfer or to discharge a security interest. Then we're going to get to the purchase price and adjustments. This section sets out the purchase price, the payment mechanics, and any adjustments that are to be made. For example, the working capital peg we discussed in episode 4. Any holdbacks, any earnouts will also be in here. Now, if these were properly defined at the LOI stage, this section will largely reflect what is in there and might have some minor tweaks. But if they were left vague at the LOI stage, now is where your vagueness is going to get expensive. A lot of time and effort will go into finalizing. Then we have the representations and warranties of the seller. This is typically the longest section of the agreement and often the most heavily negotiated. The seller represents and warrants a long list of facts about the business. These might include such things as the accuracy of the financial statements, the absence of undisclosed liabilities, the validity of material contracts, the state of corporate records, compliance with applicable law, the absence of current litigation. And we covered this disclosure schedule that qualifies these representations in episode 8. That work is fully in play here. Then we have the representations and warranties of the buyer. This is typically much shorter, but the buyer is basically going to say they have the authority and capacity to complete the purchase, and particularly relevant if there's financing or an earnout, they have or will have the financing necessary to close and perform their post-closing obligations. Then we usually have something called conditions precedent to closing. Precedent means something that must happen before either party is obligated to close. Typical seller conditions are buyer's representations remain true at closing, purchase price is paid, and any required regulatory approvals are obtained. Typical buyer conditions: seller's representations remain true at closing, no material adverse changes occurred in the business, and any required third-party consents, for example, a landlord consent on a lease agreement, has all been obtained. Then we have the covenants. These govern the conduct between signing and closing. You'll sign the contract, but it might be 30 days, 10 days, whatever, until closing. The seller typically covenants to operate the business in the ordinary course, to maintain insurance, to not solicit competing offers, and to assist with obtaining any third-party consents necessary. These covenants matter because the gap between signing and closing can be weeks or months. And the buyer wants assurance that the business they are closing on is the same business they agreed to buy. They have a right to that. Then we have something called indemnification. This determines what happens if a representation turns out to be false after closing. It's heavily negotiated, and I'm going to swing back to this one and spend a little time on it. But let's continue walking through the document. Next up, we'll see the non-competition and non-solicitation clauses. These are really important. Sometimes they get a little bit shortchanged, and it leads to all kinds of problems. The buyer will ultimately want assurance that you are not going to walk on this transaction and open a competing business down the street, or poach your former employees or customers. And we'll cover the negotiating parameters here shortly. And then finally, we go into closing deliveries. This is a detailed list of what each party delivers at closing. It might be share certificates, asset transfer agreements, obviously the purchase price, corporate resolutions, other certificates, ancillary agreements like transition service agreements, vendor take-back notes, and other things that might be specific to your deal. So let's go back to that indemnification. Here is where, if you're the seller, you need to fight the hardest. And if you're a buyer, you need to be very alert to what's going on. If you remember one section in this episode, remember this one. Indemnification is the seller's obligation to compensate the buyer for losses that have arisen as a breach of the representations or warranties, or from a specifically identified risk that was disclosed and allocated in the agreement. The parameters of this obligation are negotiated, and they have a direct dollar impact on your risk after closing. So how long do they survive? Well, this is something you negotiate. A year, 2 years, 18 months is a common commercial position for general business representations in a Main Street transaction. 2 years or longer certainly gives the buyer more time, but it leaves you more exposed. Then there are fundamental representations that are a little bit different. Your authority to sell, for example, your title to share assets, the absence of liens. These typically survive indefinitely or until the statute of limitations for a claim runs out. This is standard. This is very reasonable for you as a seller to accept. But push hard on limiting the survival period for the general business representations, the ones about contract, financial statements, and operations. It's also good to have an indemnity cap negotiated. What is the maximum amount that you could be required to pay on these? If you don't have a cap, it could be unlimited. Commonly, this is capped at the full purchase price for fundamental breaches, but at a meaningfully lower amount, say 20%, maybe up to 50% of the purchase price for those general contract breaches. So negotiate this number. It's the ceiling on your worst case exposure. Then we have something called the basket. This is a minimum threshold of losses the buyer must absorb before you have any indemnification obligations at all. A basket protects you from nuisance claims over minor issues. Just for example, you could have a buyer theoretically come and say they found a $5,000 discrepancy on a $6 million deal, and they want you to pay them $5,000. This is a nuisance. You don't want to be doing this and then coming back a month later for another one and 6 months later for another one. So we often express these under a percentage of the purchase price. This way, small claims don't trigger your obligation. And then you have a holdback. In many transactions, a portion of the purchase price, commonly 10 to 20%, is held back, often in escrow, that means held by your lawyer in trust, for a defined period after closing, and that is there to fund that indemnification. The holdback amount, the escrow mechanics, and the release schedule are all negotiated points. From a seller's perspective, the goal is to minimize the holdback and shorten the period before it's released to you. Now, there's one other thing that's really important, that is the material adverse change clause, or the MAC clause. A materially adverse change is if business operations change between signing and closing. From a seller's perspective, this clause needs to be very carefully defined. A poorly drafted MAC clause gives the buyer an exit ramp for almost any negative development. A general economic downturn, an industry-wide slowdown, or a single lost customer. A well-drafted MAC clause, from the seller's perspective, excludes general economic and industry conditions and is limited to changes specific to the business that are genuinely material. This is a heavily lawyered provision. Do not accept the buyer's first draft without a careful review. Now, I get a lot of questions about non-competes. What is enforceable in Alberta? Buyers will want a non-compete covenant restricting you from competing with the business you just sold. This is standard. This is generally reasonable. The buyer's paying for it, after all, and that goodwill that he pays for includes the expectation that you won't immediately undermine it. Under Alberta common law, a non-compete clause must be reasonable in dimension to be enforceable. In the dimension of duration, geographic scope, and the scope of restricted activity. A non-compete that is unlimited in time, unlimited in geography, or that restricts activity beyond what is necessary to protect the purchased business is at risk of being found unreasonable and therefore unenforceable in an Alberta court. 2 to 3 years is a really common commercial position for duration on a common Main Street business. The restricted activity should be defined specifically, restricting you from the particular type of business sold, not from all commercial activities generally. You want to negotiate these parameters carefully because an unreasonably broad non-compete may be unenforceable. But it may lead to litigation, and it can become expensive, and the uncertainties cost money. It's far better to negotiate reasonable terms up front than to rely on a court striking down an unreasonable one later. Okay, quickly to closing day. Let me demystify closing day itself, because for many sellers, this is the part of the process they understand the least. In most private Alberta business transactions, closing is a coordinated event. Historically, it was in person, though now it's almost always virtually, with documents circulated electronically and signed in escrow and then released simultaneously once all conditions are confirmed and satisfied. At closing, the seller delivers the closing documents, share certificates with proper endorsement, or a bill of sale and assets, transfer documents for an asset sale, along with corporate resolutions authorizing the transaction, officers' certificates confirming the representations remain true, and buyers will, of course, deliver the purchase price, typically by wire transfer today, along with any notes and security documents and other considerations agreed on in the purchase agreement. For a share sale, the corporation's share register is updated to reflect new ownership, and the directors typically pass a resolution approving the transfer, and where applicable, appointing new directors and officers for the buyer. Once all this happens simultaneously, the deal is closed, and the keys literally and figuratively change hands. Legally, we call this key release. After closing, a few things continue. Closing day is rarely the complete end. If there is an earnout, the measurement period continues, often for 1 or 2 years. If there is a holdback, the escrow period continues until the holdback is released, subject to any indemnification claims made during the period. If you agree to transition services, of course, you're going to be engaged directly in the company. And if the seller is financing through vendor take-back note, you remain a creditor until the note is paid. Well, if you followed this series from episode 1, you've now walked through the entire arc of a business sale, from the moment you first asked whether your business was actually sellable, through corporate cleanup, valuation, the market process, the LOI, the structured design, decision between asset and share sale, due diligence, and now the purchase agreement and closing itself. That's the work. Years, sometimes decades of building, and now a carefully, well-devised process of letting go. In our final episode, I want to talk about something a little bit different. Not another legal topic, but a conversation about what it actually means to have the right team on your file throughout this entire process. What getting to yes looks like in practice, and why it matters more than almost anything else in determining whether your deal actually closes. If you're approaching a purchase agreement right now and you want experienced counsel in your corner, visit chadgrahamlaw.com. Full transaction representation from early investigation, the LOI, through closing is exactly what we do. I'm Chad Graham, and I'll see you in the final episode.